The tone and the wording of TV licensing letters is so bad recently, in my view, that it might found a successful claim in harassment against them, and I'm going to explain why. But just before we do that, if you could do me the brief favour of clicking subscribe down below, only if you find the videos useful or entertaining or all of the above, and I'd be really grateful. I depend on you, the viewer, to get me to 1 million subscribers. I would really like that, so then I've helped at least 1 million people in one way or another. And in this instance, TV licensing, because I really object to the wording in this letter. So let's take a quick look at this. So this again is sent by one of my kind viewers. One of you guys sent me this letter. Now there are many like this, but this one's mine, as they say. But there's a specific wording or collection of wording in here, and the fact that these letters come out again and again and again, that in my view it could well amount to harassment. And I'll explain why in the second half of this video, with reference to an actual case where there was a successful claim in harassment because of letters. Come back to that later. Let's look at this first of all. Let's turn my arrow thing on so I can do little drawings here. Right, now let's analyze this. Now, the very first thing you look here is 10-day window. This is giving you a time frame. Now, when we look at cases in civil litigation, we give each other time frames. For example, there's a story I'm going to tell you about very soon, in which case I received a letter that was not compliant with the practice direction on pre-action protocol, which is to give you at least 14 days to respond to a prospective claim, or 3 months if it's a really complex one, and they gave me 7 days. So that wasn't a compliant letter. I'll talk more about that later. But when we give each of the time frames, it's so that you've got a fair opportunity to respond and consider the case, etc. Now, this giving them a 10-day window is a bit odd in the sense that I don't know where the 10-day window bit comes from. But nonetheless, it's giving this person a time frame, which sort of starts to add pressure. What is going to happen in 10 days' time? Well, they detailed that in the letter, which is one of the reasons I think this might ultimately amount to harassment. Again, I'll come back to that. And it says here, if there's any doubt, we are giving you a 10-day window to get correctly licensed. Reasonably aggressive tone. Now, just for the avoidance of doubt, correctly licensed includes not having a license. If one does not have a license, but one does not watch or record live TV, and they don't consume BBC content on BBC iPlayer, and it doesn't matter the device and the program and everything else, but if they don't do those things, they don't need a license. And that is, for the avoidance of doubt, being correctly licensed, because you don't need one. If you do any of those things, obviously you need a license. That's not the point. Let me know in the comments what so far this is. We're not done yet, but just so far, let me know what you think about the content and the wording and the tone of this letter. If you received this, or if you have received one of these or anything like one of these, do you feel that this is oppressive? Do you feel that it's unacceptable? Because that comes into the definition of harassment, which we're going to come back to in just a moment. But first, a quick diversion. On another note that might shock you to the core, one way that is open to TV licensing to obtain information about you, your name, your address, and perhaps the fact that you own a TV or something like that, is to buy it from a data broker. You see, every time you buy a TV, or anytime you buy anything that's linked to a TV, a film, a DVD, whatever, your information may then be on a database somewhere. And you remember that little phrase that says we may share or whatever your data with third parties? Well, some of them package that together and they sell it onto other parties. Now, it is open to TV licensing to get hold of that data from these data brokers. There are hundreds of these data brokers, and it's for that reason that I make no apology to recommend to you a company called Incogni that I work with on this channel. They, if you instruct them, will go after all these data brokers and insist and require that they delete and remove your information from their databases. Now, if it transpires that they end up selling it later, you can sue them because they are required to remove it in accordance with data protection laws. Now, this not only will protect you against things like companies getting your information when you really don't want them to have your information, but it would also prevent much further down the line from nefarious actors getting hold of your information if it ends up on the dark web and then they start taking out loans and credit cards and things in your name because they've got just enough information about you to convince a financial institution that they are you. And that really does happen. I've had clients that that's happened to. Of course, you get a discount with this service because they're a partner to my channel. Use the code BlackBelt to get a 60% discount with a 30-day money-back guarantee. Then you'll get access to a dashboard and you will see regular updates as to how many companies they've insisted remove your data. And you will be amazed at how many hundreds of these companies come back to confirm that they've removed your data from their databases. This is a staggering misuse of your personal information. Misuse in the sense that you would never have agreed to it if you really knew what you were getting into. Now, this is very much a cleanup operation. You instruct Incogni, it's very easy to sign up. They do all the work for you. It would cost you countless dozens of hours to do the same amount of work, but they go after these brokers and insist that they remove your data. That is absolutely worth it. I strongly recommend it to you. Use my discount code BlackBelt. The link's in the description and you will thank me later. Now, back to the letter. It says, these days, there are many more TV channels to enjoy, but to watch live TV, you need to be covered by a license. True. As this address does not have a license, it's now under investigation. Now, that in itself, again, is adding some kind of stress. Would somebody let me know in the comments if you receive a letter like this? Would you be, and I know it's true because a lot of people that I've spoken to have said exactly this, even friends of mine, have genuinely come to me and said, what do I do about this? Because they are genuinely terrified by these letters. Let me know in the comments. Would you be alarmed and distressed because of receiving a letter like this that says you are under investigation because you don't have a license? Let me know. Normally, it says you could expect a visit at any time. Well, that's not fair either, because it shouldn't really be outside of business hours. And at home, it shouldn't, for example, shouldn't be after 8 or 9 in the evening. You shouldn't expect a visit at any time. That is unreasonable and I might suggest oppressive. However, to help you get correctly licensed, we're putting your case on hold. Now, this is a bit that I really take issue with. Your case. Now, this is not a case. A case is when it's been issued by a court or there is a crime number because it's a crime and there's a case number, there's a reference number, there is an actual case. This is not a case. This is just some investigation by TV licensing or whoever on behalf of BBC. Putting your case on hold. Now, in civil litigation, that will be referred to as a stay. You've issued, I've got one sitting over there right now. You've got a case issued by the court, so you've got a claim number, and you might apply to the court for a stay to say, we're trying to work things out, just cool it for a bit. Just hold on to the documents for a while. We'll be back if and when we need to come to court for a hearing so the court can rule on something for us, whether that's the substantive case or a bit in between, which you call an interim hearing. Just stay there for a minute. It's called a stay. Now, this can't really be a stay or being on hold because there is no case. It's just them conducting some kind of investigation. For the next 10 days, they say, please use this 10-day window to sort out your TV license. So in other words, buy a license, they say. Now, you shouldn't have to buy a license if you don't need one, because not having a license might be correctly licensed, as I said. Then it says, without a TV license, you may be breaking the law. Well, you may, only if you watch or record live TV or BBC iPlayer content from BBC. And then it says, no matter what device you're using, etc., you need a TV license to watch or record live TV on any channel, correct, not just BBC. Watch or record live TV on any of those, that's correct. Watch live TV on any service, that's correct. Being covered, and this bit's wrong with respect, in my view, be covered for everything on BBC iPlayer. Now, BBC website itself, or TV licensing website itself, says you do not need a license for S4C content, which is on BBC iPlayer. I don't know what else is on there that may not require a license, but it's only BBC content on BBC iPlayer, so that's wrong anyway. Anyone doing so without a license should expect an enforcement visit and risks prosecution. Well, which is it? Because you can't enforce anything unless you've got something to enforce. If it's a civil debt, you need, first of all, you need a judgment, and secondly, you need an enforcement order, to a writ or a warrant of control or something else, or a possession order, or something to enforce that judgment debt. Or if it's a crime and there's confiscation proceedings, you need a confiscation order where they come and they confiscate the money that you've acquired in a criminal activity. We call that the benefit. And here it says enforcement visit. What are you enforcing? Unless you actually have something to enforce. And risk prosecution, well, it can't be both at the same time. You can't be risking prosecution, but they're enforcing something that doesn't yet exist. And then it says you only have until the 25th of December to act. That's not true. If you don't need a license, there is no time limit. You don't need to wait for any time limit whatsoever. And then it says, if you do not get in touch, your case will be escalated to the enforcement team. Now, enforcement team, what are they enforcing? There's a team. Is there a team going to come around and visit you? Because if they don't have a license, they have no right to enter your property, and you don't have to answer any questions and so on. It's different if they have a warrant. So that's the caveat. If they do obtain a warrant, you need to take that seriously. But for that, they would need to evidence that they're going to find something that will substantiate the offence if they turn up. And then they're going to schedule a visit and find out why there's no record of a TV license at the address. Now, for the avoidance of doubt, you do not have to answer their questions unless they have a warrant, and then you have to provide reasonable assistance while they inspect the equipment. Still doesn't say that you have to answer their questions. That would need to be in accordance with interview rules and all such like. And so back to the letter and why I say it might amount to harassment, because here's one such case where two individuals sued a local housing trust because they say that they were harassed by receiving letter after letter after letter threatening legal proceedings, and none of which were ever brought. But they were threatened with them, and they said that they felt alarmed and distressed, and that this amounted to harassment. Very long story short, these two individuals were accused of breach of their tenancy agreement by the housing trust by having CCTV at the property. As it turns out, Mr. Worthington in this case didn't ever have any CCTV at the property, but they were accused of having CCTV. They were sent letter after letter threatening an injunction, threatening that they'd go for a possession order and evict them from the property and so on. And they said that this amounted to oppressive conduct and therefore that it was harassment. They were successful in the claim for harassment and even successful when that decision was appealed. And in the conclusion to the appeal at paragraph 80 here, the judge said, I accept that a reasonable person would think that the association's actions, i.e. all the letters and the threats of litigation, etc., would cause alarm and distress to Mr. Worthington and Miss Parkin. I reject the submission that the letters in issue were unexceptional and of a kind regularly sent by owners of social housing as part of their efforts to protect the wider body of tenants. So in the case, the association said, well, we send these letters all the time. These are just run-of-the-mill, unexceptional letters, and they shouldn't be alarmed by them. The judge rejected that and said that they were letters that they might reasonably be alarmed and distressed with. Judge said Mr. Worthington and Miss Parkin were threatened with possession proceedings and accused of antisocial behaviour and taking inappropriate images. Such proceedings, if successful, would have meant that they would have had to seek accommodation with a different housing association, yet the association issued those threats without taking the most basic steps to ensure that they had proper foundation. They were, in fact, totally unjustified. I am satisfied the judge, the original judge, had ample material before him, which to find that the conduct complained of crossed the boundary and was oppressive and unacceptable, and that it amounted to harassment, and therefore dismissed the housing association's appeal on the original decision. Now, there are some examples of those letters up here in these highlighted sections. These are examples of the letters that came out. And they varied in tone and content and so on. And this one said, we've been instructed by the above whose advisors concerns about CCTV cameras. Other residents have made complaints and all of these sort of allegations. Now, in short, those allegations ended up with allegations of tenancy breaches, and the association said, I'm writing to you further to recent correspondence about the CCTV. Despite your assurance that you do not have and never had CCTV, this was to Mr. Worthington, we've evidence to suggest that the cameras were in use at the property very recently. And you'll be delivered a notice of seeking possession within the next few days, and we'll notify you of further legal action. And obviously they were pursuing an injunction and threatening them with possession proceedings. The judge, in response to these letters, said both of these letters were inaccurate in serious respects, and this is why it links back to the TV licensing video in just a moment. The judge said, in the case of the letter to Mr. Worthington, he had never had CCTV cameras at his property. The petition that they referenced had not been signed by 80 residents, and he'd committed no breach of his tenancy, let alone a serious one. Now, this links back with the TV licensing thing, because if someone is not in breach of the Communications Act by watching or recording live TV without a license, i.e. they only watch YouTube, not live TV content, and they only watch Netflix, not live TV content. And therefore they don't need a license, but they are being threatened with prosecution again and again. Threatened with, as I quoted from that letter before, enforcement. The wording of this letter, each and every time they use the words enforcement team. We are going here, you risk prosecution, you risk breaking the law. We're going to send an enforcement team. There's a 10-day window. You only have until the 25th of December. Well, that is not true. Because if you don't need a license, there is no only until the 25th of December, which is Christmas Day, which makes it even more oppressive in my view. Again, let me know below if someone said to you, if by Christmas Day you don't do this, we're sending a team round, an enforcement team. Would you feel oppressed by that wording if you genuinely don't need a license? Because most people, I suspect, are not going to instruct a lawyer at several £100s an hour when the TV license is far less. To get advice on whether you really need a license or not. One of the reasons I do these videos is not for advice, but for guidance as to whether or not you need a license, and explain it to you, and explain why I think letters like this have gradually over the years got heavier and more aggressive in tone, and in my view may well amount to a successful claim in harassment. Now, just to explain why this morning or yesterday, somebody said, why am I always caveating and said it might be this and it might be that? Well, I'm avoiding the scenario where I say this is 100% definitely X, because then somebody might act upon it. Now, whilst this is not intended and is not to be taken as legal advice, I don't want to risk someone taking it as legal advice. So I always say this might amount to harassment, it might be this and it might be that, because this is guidance after all. Now, whilst strictly speaking, I could tell you definitively this is wrong, but at the same time, it's not legal advice. It sounds counterintuitive, but legal advice would be, we're under contract, you pay me, we sit down, you tell me everything, I ask questions, and I say this is my formal advice. And so this is not. This video is just me being a little bit disappointed with the wording and the tone of these letters that make ordinary, reasonable people in fear of and alarm and distress, because in particular this one coming up to Christmas, you only have until the 25th of December to act. That, in my view, is unacceptable. Let me know what you think in the comments below, but I think in reference to that case there, somebody, if they were so minded, could crowdfund a case and have a really good go at this. Again, not legal advice, but it is entirely possible the judge might rule and say, these letters are oppressive, especially if you've got dozens of them. As one person last year sent me, I think it was like 50, 60 letters or something over a 4 or 5 year period. To me, that is oppressive, and that is the point of this video. So I hope you found that useful, interesting, entertaining somewhat. If you do, please do like the video. That's the little thumbs up button. Subscribe to the channel if you haven't already. Check out my other channels where you get my personal views on things, Black Belt Secrets, link below. And if you want to have ideas of how to make money and create wealth, especially in these times that we're in at the moment with all the taxes flying around, my personal channel, Daniel Shansmith, link below. And with that, I thank you for watching, and I'll see you next time.